A few logistical items. First off, those of you in the room have a printed booklet that has a copy of the PowerPoint slides and bios for our speakers here today. Those of you on the telephone received an email with dial-in information, of course, and a link to the PowerPoint slides for today's program. Tomorrow, all of you will get an email that will contain all of the handout materials as well as a link to a recording of today's program. Feel free to forward that email on to colleagues or others who might benefit from that. And as many of you know, we've hosted all of our recordings of our 3+ years of nonprofit legal programs on our website for a number of years, but we migrated those over to a special YouTube channel that we created. There's a link to that on the last slide of today's PowerPoint presentation. So if you want to go back and view the webinars and listen to the recordings of several years worth of some pretty interesting webinars on a wide variety of topics, including quite a number on nonprofit legal topics, especially if you like hearing from Dave and Megan. I think there's a few oldies but goodies. Dave's done quite a bit, actually. And there's some really good stuff there that I encourage you to listen to. There's also links on the last slide to the section of our website where we have about 750+ articles and PowerPoint presentations on every conceivable nonprofit legal topic. For today's program, we are going to encourage you to ask questions throughout. We think that today's topic lends itself well to that. So for those of you in the room, raise your hand when you want to ask a question, and we have Marion and Alana in the back of the room who will walk around with a microphone so that everyone on the phone can have the benefit of hearing the questions and then, of course, hearing the answers. And for those of you on the webcast, pose your questions to me using the chat feature on the webcast software, and I'll pose those to our speakers at the appropriate times. Preview of our next 3 scheduled upcoming nonprofit legal programs, always here at Venable from 12 to 12:30 Eastern Time. We offer lunch for anyone who can join us, and then from 12:30 to 2 o'clock Eastern, we do the live program with a live webinar component for those of you in D.C. and around the country that can't join us in person. On July 17th, our program is entitled Key Trademark and Copyright Rules for Nonprofits to Follow and Break. Interesting development on the trademark front today with the U.S. Patent and Trademark Office canceling the federal trademark registrations for the Washington Redskins, which is an interesting development, which we'll have some commentary on and implications for nonprofits. August 13th, our program is entitled Privacy and Data Security if you're a nonprofit, Understanding Your Legal Obligations and Insuring Against Risk. Insuring with an I, speaking of insurance, of course. And finally, on September 16th, What's Ahead for 2015, Preparing Your Nonprofit's Group Health Plan for the Employer Mandate. 3 terrific programs that I hope you can join us for. And if you're not able to join us for them, always go to that YouTube channel afterward, the day after. They're always posted there. And for those of you who come from the Trade and Professional Association community, our attendees tend to be a pretty good mix of folks from trade and professional associations, charities, foundations, think tanks, and others that serve the nonprofit community. But for those of you who are certified association executives, good news, starting July 1st, so with next month's program, all of the programs that we do here will be eligible for CAE credit for continuing education purposes. So for those of you who have your CAE designation, you'll be able to get credit for attending these programs, and that'll be made clear on the materials that will go out for the July program. Okay, with that brief introductions, I don't want to take much time, and then you have full bios of our speakers in your handout materials. But to my far right is Dave Warner. Dave is a partner in Venable's labor and employment practice, has worked closely with me and hundreds of our nonprofit clients for many years. Dave is cream of the crop when it comes to employment lawyers, not only knowing the law, but having just a terrific, practical, nuanced understanding of how these very difficult issues play out, particularly in the nonprofit context. He's been a trusted advisor to many of our nonprofit clients for years, and he's also been a great mentor to some of the associates in that group that also do a lot of work with our nonprofit clients, one of whom just had her baby last week, and another whom is right here.
No, I didn't just,
and we'll
I
be
didn't
having
just have
her
my
baby relatively soon.
Really an Irish twin that she's going for here.
So as you can tell, I'm very concerned about what Dave's backup plan. But no, congratulations to Marina Blickley, and to Dave's left is Megan Mann. Megan is an associate in Venable's Labor and Employment Group. I got to know Megan when she worked in our New York office. Thankfully, she came down here, so I get to see her more often. She's a terrific lawyer, also a terrific speaker, a lot of fun to work with, really terrific employment lawyer, and you're going to get a lot from Dave and Megan here today. So with that, I'm going to turn it over to Dave to get us started. Dave?
Thank you, Jeff. First, just going to set the stage here with what we're going to be covering. We'll start with a discussion of what we like to refer to as the principles of performance management and discipline. And what you'll find very quickly is that the two topics, or the two tools in the management tool set, while separate and apart, are very much related, and the concepts echo one another, and they're very much intertwined. We'll move on to avoiding common pitfalls, and what we mean there is the types of issues that we see nonprofits, the areas where we see mistakes get made, where we get called in to try and clean up problems, to help you identify issues and to avoid those issues. One of the common pitfalls that we really don't touch on in the deck, and it's entirely self-serving, so I will state it now, is not getting counsel involved soon enough in the process, particularly if you're in an organization that doesn't have a robust HR, either practice or HR professional that you can consult with. Very often we get the call too late in the game, be it, hey, we just fired someone and now we've got a demand letter from a lawyer, what should we do? Oftentimes people say, well, we didn't want to talk to you because there's expense associated with that. It's true. There is expense associated when you're dealing with outside counsel or outside consultants. But understand that if you get into a litigation footing, the amount of money that you would have spent on the front end in counseling is going to be a rounding error in the first month's litigation budget. So I encourage you, when you're dealing particularly with termination issues, make certain that you have coverage of either experienced HR or outside legal counsel, or in some certain circumstances, both can bring value and different perspectives. The other good thing about consulting with legal counsel is I'd like to say we serve as both a sword and a shield. So particularly when something goes wrong downstream and an executive is trying to explain to a board, why something happened, the ability to say we've been working with counsel throughout this process provides significant cover for executives in those types of circumstances. So again, having us involved in that process gives you cover and tends to lead to better results. We're going to close with using PIPs, performance improvement plans, and other tools to address some of the common problems that we see. What we like to think of is that the approaches, there's no one approach, there's no one progressive discipline system. It's not always a one-to-one match, but we'll talk about both conceptually and use some examples, some hypotheticals about where we've seen effective uses of the tools that are both effective in terms of managing your organization and effective in ensuring that you're on a very defensible footing should a claim be made, should you end up in litigation. Now, I like to start this with a show of hands, talking about looking at your own organization and your own performance evaluation process. And I'm actually going to start at the bottom of the list with the question of how many in the room don't have formal annual evaluation processes? That's interesting. I was going to say, I saw one.
Don't be shy.
Yeah, don't be shy on that one. And I will be the first to tell you, it's particularly smaller organizations or newer organizations, the HR side tends to lag. And there are oftentimes organizations that simply don't have formal evaluations because they haven't needed to. They do it informally. There's also a school of thought that the performance evaluation process can give rise to bad facts or bad evidence. And there's a school of thought both in terms of the management bar and HR professionals that are suggesting a move away from annual performance appraisals. I, for one, do not buy that. I would agree that performance appraisals, performance evaluations done poorly can lead to problems, but I think there's sufficient value in them that it's good that organizations have them and follow them. So we'll go through the other ones, and I've asked Megan to respond on behalf of Venable as to our own performance appraisal, and she has suggested she will respond at least semi-truthfully.
Yes, that is accurate.
So again, just a show of hands, my nonprofit's annual performance evaluation is a very useful tool. A few more than non-existent, but I won't say that was the overwhelming. Not as effective as I wish it was. Sort of overwhelming response, and a total waste of time. Thankfully, none on that one.
At least not in the room.
Yeah, I speak online. I always find that question fascinating, and I always want to ask the question of why. and how can they be improved. But the candid answer is we could spend the rest of the day and probably the rest of the week talking about flaws in performance appraisal processes and the like. But I encourage you, if it's not as effective as you think it ought to be, to pose the question both to yourself and to other leaders in your organization and see what's not being done. How can we do this better? Because you can get a tremendous amount of value from good performance appraisal and performance evaluation practices.
Dave, before you go on, maybe it's worth commenting just from a legal perspective, since we are lawyers talking about this, that in addition to the many important management and operational reasons to have a good performance management plan, from a legal perspective, what are some of the biggest risks and dangers when you don't? What are some of the primary reasons from a legal perspective why it's so critical to have a good performance management program in place?
Yeah, it's a good question, and generally I think it comes down to leaving aside the operational necessity of it and the value it can bring. In the legal world, it's documentation. And while it is great to have good witnesses, strong witnesses, people that remember things, the fact of the matter is, management change happens. People retire, people move to new organizations, and it's much more credible when you have timely documentation, particularly if someone is performing poorly and goes down a disciplinary path or is moved out of the organization. It's one thing to have a manager say, yeah, they were a low performer. It's quite another to have a document that goes through job-related criteria and evaluates on each of those criteria, and we can point to where this person was falling down, where they were given opportunities to succeed and the like. So again, going back to that question of, the notion of you're better off without them, I disagree. I think they need to be done correctly, and we'll talk about how you can do that. But they're an extremely powerful tool if and when you find yourself in a litigation footing.
And Dave, so what about the manager who says, well, these are all at-will employees, none of them have contracts, we can fire them at any time for any reason, or at least any non-illegal reason. So why does it matter? Why do we have to waste our time with all of this?
Yeah, we get that question a lot when we're counseling people on discipline and termination. I thought this was an at-will state. Well, it is, technically, but it doesn't mean you're not going to be sued. And that's why having that documentation becomes so important, because it's all well and good to say, well, this employee is at will, I can fire them for any reason or no reason. That's true, but it also costs no money for this individual to file a charge with the EEOC or DC Human Rights or any of the other state analogs. And it costs very little money to file a lawsuit. And people, we get it all the time, say, well, no lawyer is going to take this case because they don't really have one. They'll be able to find a lawyer. There are lawyers that will take anything that walks in the door because they need to. Maybe they're a small startup. Maybe that's just their model. They write letters and they settle. They're not going to be vigorous advocates, but they'll get a check or they think that they can shake the money tree. So that notion of at will protects us, and this case is so bad no one's going to sue us. In reality, it just doesn't work. So that's why having that documentation, having the support, and being able to defend is so important.
And also, just to add to that, David and Jeff, one of the things we find is that an employee is much more likely to walk into another lawyer's office or walk into an agency to file a claim when he or she is caught off guard. And we'll get into this more later, but when an employee feels that the rug was yanked from under them, a natural conclusion for many individuals is, it must be that I was wronged some way. They're breaking some sort of law. It is because of my age or some other protected characteristic. Whereas when you are creating this documentation and this performance plan to kind of put the writing on the wall, I mean, that's not the point, but it has the incidental effect of doing that, then there are no surprises if ultimately somebody does need to be terminated. So it's just, again, going into that sort of legal realm of the benefits.
And we understand that sometimes people either don't see the writing on the wall or refuse to see
right.
the writing on the wall. But having it on the wall is very important.
And just to close the loop on that, so even if someone does see it coming and does make them less likely to file a complaint and bring a legal action, it doesn't mean they won't anyway. And it doesn't mean the nonprofit, the employer, won't have to defend against that. And so another way to look at this is, even in an at-will situation, which is the vast, vast majority of all of your employees are going to be at-will employees, so you can terminate or demote for any reason or no reason, as long as it's not an illegal reason. such as because of an employee's protected, one or more protected characteristics under federal or state law. And so what this becomes in a situation where someone is making an allegation that, no, you didn't fire me because of my poor performance, you fired me because of my race or my sex or my age or my disability, it comes down to a question of how do you prove that? And that's where performance management is so critical, and documenting employees' performances, like Dave said, especially poor performance, so that when it does come time to terminate that individual, like Megan said, they have seen it coming, so they're going to be less likely to bring some kind of an action. But even if they do, you have a thick file of all of the record of poor performance and the efforts to let the employee improve. And then in the end, you show that they failed to, and that's why you had to pull the trigger. That makes the employee's claim a lot more difficult to prove in the end.
Now, with that tangent, I think we've covered everything we wanted to, so thanks for coming out. You've been a great audience.
Take a brownie on the way out.
Moving on. The first principle of performance management is that there's no bright line between where performance management ends and where discipline begins. And the same conduct in different circumstances, you may want to use one tool or the other. And the example I always use, and I've given this speech before with Marina Blakely, and she always hates this example, but I use it all the time because I can't come up with a better one, is my assistant. She is terrific. She keeps the trains running on time. My practice would fall apart without her. Absolutely love her. Now, I am not one as an employment lawyer to traffic and stereotype. But she is an Irish Catholic girl who grew up in Queens. She is prone to salty language. As I say, she's terrific once you get used to the level of profanity that you have to deal with. Now, that being said, let me say she is unfailingly professional. On the phone, in person, she's fantastic. But she is who she is. Now, I use this example because I think, do we have rules against profanity in the workplace? Of course we do. And if one day I came in and she used inappropriate language and I said, Colleen, that's against the rules, you're suspended. Or going back to the at will, it'd be perfectly lawful for me to recommend her termination for violating one of our policies. But would that be effective? Would it be fair? Would it be perceived as fair by her? Because as Megan touched on, that's what gives rise to claims. It's not were you right. It's not whether we can come in and defend you. It's oftentimes, how did the employee feel? Did they feel that they were being treated correctly? And that's really, I think, the crux of, in a given situation, are you on that performance management spectrum or are you on the discipline spectrum? And that's an issue that should always, before you start walking down one of those paths, think about it, think about the perception of it. The two are inextricably linked. But you need to make that determination. Is this, in this situation, yes, it was a violation of a policy, but are we on a performance management path or are we on a discipline?
And would you have to fire all of the partners in the office?
it would get a little lonely. But with that,
okay, and so David touched on this a little bit, but a really important thing to think about with performance management, so what is the purpose? Like anything we're doing in business or in an association, we have goals, we have objectives, and then we think of the best laid path, at least the best one we can think of, to reach that goal or the objective. And performance management is no different. You don't want to do a sham performance improvement plan. There's no point. You want to think of a methodology that is going to be effective, that is going to be useful. And the point is to provide a fair and accurate evaluation of employees against standards required for success in their positions. So an important thing to think of here is, what are those standards? And it's a great thing for employers, HR, management to be able to identify and articulate what standards are, what the objectives are in the employment setting, and how the employee can achieve that objective. So although we have talked about the benefit of documentation, we want that to be an incidental benefit. We don't want that to be the point. We don't want you to set out to paper the file. And when you do that, it can result in inconsistent and ineffective performance management. And also it can result, we've seen in claims that employees were being being targeted because of the inconsistency. And consistency is something David will drill down on further later. Also, the point is not to game the compensation system. So we don't want our managers saying, well, that Dave, that kid is great. And you like how I called you a kid there?
That was nice.
So I want to make sure that he's getting that extra 5% raise or bonus. How can I make that happen? I'm going to put in his appraisal X, Y, and Z to make sure that he gets that. Again, that type of inconsistency and lack of purpose is what can lead to not only an ineffective program, but potentially claims due to inconsistency down the road.
And on that front, it's very common that merit increases and the like are influenced by job performance. That's why we call them merit increases. But I always get nervous if there's a direct tie, that if someone gets, a 4.5 on their evaluation, they're going to get a 5% raise. And if they get, a 3.5, they get a 3%. Because what happens is managers start working backwards, is that they know what the outcome is that they want, so they're just going to put the evaluation, they're going to mark the evaluation to get to that outcome. So if that's the way your system works, I encourage you to press on that and see, really, are we providing full and good and constructive feedback, or is this simply a kabuki dance that our managers are doing because they know the comp outcome that they want to get to? Another issue or comment on the standards, if you have the same appraisal instrument for all of your employees, you probably are not using your performance management system effectively. We should have different expectations for different levels of employees and different types of employees. In a perfect world, you would look at a performance appraisal instrument and it would tie back to that individual's job description, because the job description in theory says, here's what we're expecting of you. And if that's what we're expecting, that's what we ought to be judging this person on. And I don't mean judging in a pejorative sense, or evaluating that person on. And if they're failing in any areas, that's the whole purpose of it, is say, Megan, you could be doing better on this aspect of your job. Not that there's any aspect of your job that you should be doing better on. But think on that, because oftentimes we get the question of, well, do you all have a preferred performance appraisal instrument, or do you have the one that you've defended? The answer is yes, there's ones that we've defended and have talked about and we think are effective, but they're effective in a given context. There is no perfect form, and you really do need to be, whatever forms you're using, need to be tailored to the individual's job. And that's a place where oftentimes we see a disconnect between what ought to be happening and what is happening in practice.
Thank you, Dave. So other principles of performance management that we'd like to review with you, the first is regularity. Although I know it's difficult, we all know it's difficult to say on January 5 annually all employees are getting X. That might not be realistic. However, having a time frame where you can say annually or biannually these employees are being reviewed, or even where you have a large organization, I know sometimes it's a rotating system where you have certain employees 1 month and then the next month, but at least again you're getting that annual or biannual or sometimes even quarterly review, whatever's working for your organization. But it's something that not only then you can rely on and expect that sort of regularity, but also your employees too. I have to say, when we get our reviews, it is something that the associates, I don't want to say they look forward to it, but they know they can anticipate it. They know that's when they're going to get the feedback, and that's productive to have that sort of system that you can rely on. And then additionally, just from sort of an anecdotal standpoint, I'll tell you I was recently working on a litigation where the organization, who shall obviously go unnamed, did not do regular reviews, and there was an incomplete review that if it had been completed and had then been delivered back to the employee, would have just been the best piece of evidence in this litigation. But unfortunately, the organization did not adhere to a regular system, and so I had a virtually worthless piece of evidence that could have really, really helped the organization. So again, as we've touched on, you want to think of not only sort of the practical, operational aspect of things, but also the litigation risk. Objectivity. Now, this is a tough one. I know. These things are inherently subjective. But as David has said, to the extent that you can articulate and identify these objective standards that are appropriate per position, per organization, per employee, and then help the employee achieve or reach those objective standards, and then provide objective feedback as to whether or not they are achieving those goals. That's incredibly helpful, and you avoid issues like people just not liking each other, not getting along. To the extent we can try to make this subjective practice more objective, that will improve it all around.
Yeah, and the other issue with the objectivity is when you're thinking through, particularly when you're identifying a deficiency, is not necessarily being objective as objective versus subjective, but what's the observable behavior that you're seeing? What can you point to? Because it's one thing to say that this person has a bad attitude. That's a fairly subjective judgment. It's another to have comments that call back to meetings in which there was eye rolling, or meetings in which this person couldn't move off of certain topics. How is that attitude evidenced? If you were questioned in a deposition, you say, okay, well, you say she's got a bad attitude. Help me understand what you mean. Sort of unpacking that. And when you can unpack those concepts with actual observable behaviors, that tends to make for a much stronger document.
A much stronger document, and then also a more reasonable plan for the employee to improve upon when you can actually give examples. A lot of employees really struggle when they just get this, you have a bad attitude. What do you mean I have a bad attitude? What does that mean? And so again, it's harking back to this, what is the purpose, and how can you help employees sort of effectuate that purpose?
And it's particularly true in your world, which tends to be a white-collar world, where we're not making widgets. We can't make them shinier and faster than the next person. That it tends to be softer issues, those interpersonal skills, things like that can be hard to explain. And so that's why they really focus on why is it that we think that this person isn't a fit with our organization? Why is it that this person seems attitude? How do I know that she's got a bad attitude? How do I explain that to someone? It's difficult, but again, it's essential to have effective performance management.
And that ties very neatly into this next one, which is the prompt identification of deficiencies. So as David just said, we want you to be able to identify those deficiencies and have some sort of objective identification. But also I want to focus in on the word here, prompt. Easier said than done, I know, but when you have let a performance deficiency go on too long, we all know there are consequences for that. There's, it's toxic. It poisons the well. Other people might be mimicking the behavior. You have somebody who's getting more sort of set in their ways, affecting their work. It depends on what that deficiency is. But then also you have, when you've let this go on a year, you have that surprise element again when you do identify it. And so we really, really, really want to encourage people to address this promptly. And David, not that we've had a problem speaking with each other, but I invite you to talk on this point, which is if you do have a regular system, I think there can also be some flexibility there where if you have, and this is something I think David's going to talk about in a little bit, but if you have a problem and it's not annual review time, that doesn't mean you sit and wait for a year to address that deficiency.
Yeah, and that's something that we see a lot. It's one of life's great ironies that many managers don't like the management aspect of their job and would prefer to not address issues because it's difficult. It's hard to sit in someone's office and say you're not meeting the expectations, and if you don't meet those expectations, your job can be in jeopardy. Those are difficult conversations for people to have. And to Megan's point, if you wait, and if you have a system that doesn't have sort of that one-off aspect to it, and encourage your managers, hey, don't wait 11 months to give this person a bad evaluation. If there's a performance issue, use other tools. Use that in performance improvement plan. Don't just sit on it and let it fester for 11 months and then drop a hammer on this person. Because again, then that looks less like performance management and more like just building the file because now you want to, you're trying to build the case to terminate this person. So I think any really effective system has to have a tool for managers to say, yeah, I understand it's now performance evaluation season, but this is an issue that we need to address. And it needn't be a formal one, but certainly managers should be held to account that they're promptly addressing issues with their subordinates.
And yes, we have a. Yeah.
Absolutely.
I think we need a microphone though, so then.
Just wait for the microphone. Yeah, while the mic's coming. There's many different ways to do that, to do these sorts of things. There is no right or wrong way. You need to find an approach that works well for your organization, for your culture, for your staff, and many other factors. Just one example of how we do it here at Venable for the partners like Dave and I. We review the associates, like Megan. We have a full associate review process that takes place in the early fall with full written evaluations from every partner or of counsel who has done any kind of meaningful work overseeing the associate. And then we have a full meeting where we go and talk about every associate by division in great detail. But we also have, we just did it a couple weeks ago in the spring, kind of a shorter evaluation process where no one does any written evaluations, but the division partners in the divisions get together and talk about all of the associates, kind of go down the list and basically saying, are there any real notable issues, problems, things that need to be addressed that we don't want to wait until the fall? And then there always are some, and the disposition of those matters varies person by person and situation by situation, but it's a helpful tool for making sure we don't wait a full year to kind of nip those problems in the bud. And a lot of times we'll put the associates on some kind of performance improvement plan. We've had some great successes grow out of that, and sometimes it doesn't work, but then by November, it's clear maybe that it's not going to work and that maybe there needs to be a parting of the ways.
And I should note, in fairness to managers, probably the only people worse at managing are lawyers. So. But yes, question, please.
I'm currently having issues.
There we go.
With my employees meeting deadlines, and I've told them that they should be better, and I've tried to be clear. But would an email system be appropriate? I outlined this deadline here. I'm following up with the email. You've been late. I had to remind you twice. I really need you to take action in this area. I mean, I don't know, what's a system?
Yeah, there's really email is a very effective tool at creating documentation because, as we know, when we're doing investigations and the like, it is surprisingly durable, or perhaps not surprisingly anymore. It just doesn't go away. It's somewhere out there on the server or on the backup tape. But to your point, you don't necessarily have to have a formal, structured system of, first warning, second warning, written reprimand, et cetera. What you want is that feedback loop. And email can be effective at documenting that the employee is being put on notice that, hey, you've missed another deadline, regarding our conference or our communication that we had, or our meeting that we had a month ago when I said deadlines are important, you've been missing them. Here's another example. If this happens again, perhaps you're going to.
That's the part I have a hard time with. Yeah. If this happens again, then what?
Well, then you make a determination as to whether a situation is solvable, or are you in written reprimand, are you suspension? I mean, if people deadlines and performance issues like that turn into, I think, discipline pretty quickly. Many nonprofits exist in a world where things like grants are very important, and annual meetings are very important. Timely completion of contracts can be very important. So it sort of depends on what kind of deadline are we talking about. Is it getting the menu right for an upcoming meeting, or is it getting the hotel contract signed on time, or is it missing a deadline for a submission of a grant that just is going to cost us $1 million in funding? Again, no one right answer, but it sounds like you're at that point of escalation.
Yeah, and one thing that I've always seen, having spent my whole professional career working with nonprofits, one of the reasons I absolutely love working with nonprofits is that the people like yourselves who work at nonprofits tend to be so dedicated, passionate, kind, nice, appreciative of the lawyers, very different from some of the folks I know that Dave and Megan and others work with some of our wonderful for-profit clients.
They're all lovely.
They're all lovely.
Lovely as code.
But the flip side of being so nice and kind, and Dave and Megan and others have seen this, it's a common trend in nonprofits, is that they tend to be a little too nice and kind when it comes to disciplining employees, or putting someone on a performance improvement plan, or even suspending or terminating someone. It's not to say that you shouldn't, keep those great parts of what makes you great at your job and makes you love doing your job. But like Dave and Megan are saying, it's so critical that when you're having performance deficiencies, you need to do something about it. You need to document it, and then at some point, you don't just keep going through that cycle. You got to pull the trigger and do something.
And also, just to add on to that, one of the things we do hear on the phone or in meetings a lot is, well, I'm scared to do this. I'm nervous to do this because although we have a good performer, he or she doesn't accept feedback well. Well, guys, that's a performance deficiency. So not accepting feedback constructively is something that an employee needs to work on. So if that's your hesitation in moving forward, you're nice and you know the person is not going to accept it well, then that's something you need to promptly identify as a deficiency. I think we have a few questions here.
Yeah.
Hi. Oh my goodness, this is so timely. I was just sharing with Veronica that I have been in conversations with one of my direct reports about her behavior competencies issues for a year exactly today. It's been a year. Yes, it has been. I work for a nonprofit, and it's a Christian nonprofit, so we tend to, as you said, Jeff, to be nice. We have to be graceful. We have to
forgive.
Right. We have to forgive.
Wait, that's part of that?
Yeah.
Even if the forgiveness causes heartburn, we have to apply biblical principles when managing our staff. So my question to you is, and I believe that I have the answer, but I just want to get that confirmation just in case. It's been a year. I started out with a informal feedback session. Then I gave her a verbal warning last August, then a written warning last November. And here I have a draft of a probation notice. So is that the right way to go?
Well, no, I understand where you're going. Of course, it's impossible to opine on that without knowing all of the background. But I can tell you in terms of a description of a process that sounds robust, that sounds consistent, to Jeff's point, with your organization's culture. I would say what you're describing is what we would like to see in terms of an organization handling a performance issue. The year is probably longer than we would have liked to see the situation resolved, but again, if that's consistent with your organization's culture, there's nothing illicit about that, and candidly, it's quite admirable. Probably most other organizations in the room wouldn't have had that level of patience. But yeah, no, what you're describing sounds like a functioning performance appraisal or performance management process or disciplinary process.
Great.
Yes.
Thank you. Stay tuned for the outcome, actually.
Okay.
Okay, we got one more question. We're going to move on.
You mentioned the use of the tool suspension, and I always wondered how you would enact a suspension as a disciplinary tool in an office environment setting, in a non-union or non-industrial setting.
It's done quite frequently. It's oftentimes not done immediately. I have had many situations where someone has received a very sort of white-hot reprimand, and then months later when they took their regular family vacation, they didn't get paid for it. And oftentimes people are just simply on leave for a given day. It's not, it's a polite fiction, but it's something that can be done. And this is jumping ahead. For hourly employees, obviously, if they're not working, you don't have to pay them. For salaried employees, if you have a policy that permits you to do unpaid suspensions, that is not a violation of the Fair Labor Standards Act. That was a change several years ago. Before, it was you could only do that for safety violations. Now the FLSA allows you to do unpaid suspensions and not risk the salary basis, but you have to have an express policy giving you that right. So it is a tool, and I'm glad you raised the question because it was one of the ones that we identify as commonly overlooked, because I think for a number of years, because it wasn't available when folks are dealing with exempt employees, and the nonprofits tend to have more as a percentage of their workforce than industrial employees, it's overlooked, and it is a very powerful tool in the tool set.
Well, and I find it's also overlooked, too, because people have, in the white-collar setting, they have certain deliverables, and they don't want to take somebody out of the loop for a week. And so you have this kind of creative solution that Dave is mentioning here, which is the unpaid family vacation or the single day leave. So it's sort of quieter, and it's not removing somebody who may otherwise be integral to your operations out of the loop at just any time.
Right.
You can control the timing.
Yeah, and it's an important piece because, for example, oftentimes when I've used the suspension of management folks, it's because you're dealing with an issue like harassment, which is very serious. And oftentimes you're dealing with an employee who's very important to the organization. So it's not saying that termination is off the table, but you're dealing with an issue where an organization is going to be very reluctant to say, Jane's not going to be here anymore. And having the suspension it's a major penalty. And the ability to show that if something happens downstream, that the organization was taking this serious, we didn't just write this person a reprimand. We actually affected their pocketbook, and that's a very, very good fact if you're having to litigate that issue downstream.
Okay, and so now jumping back to our outline, we love the opportunity for improvement. You'll see we have that down here for multiple reasons. One, it just practically speaking provides for a more productive workplace. We've just gone over the fact that we are in a room of presumably kind employers full of forgiveness. And employees like to see that if you trip, maybe your employer will help you get back up again, and it breeds a better working environment. Also, from this litigation risk standpoint, certainly giving somebody the chance to improve where appropriate is helpful, giving that second or maybe sometimes, ma'am, third, fourth, or fifth chance is appropriate, depending always on what the transgression is, what that problem is, your organization's needs. There are a lot of factors at play. It's not a one-size-fits-all type of thing. And then we also have down here support from management. We want this to be a 360 process with management in the loop, giving you as the employer feedback, giving the employees under the management level feedback so that we have communication flowing kind of maybe 360 isn't the right? Is it more up and down? I'm trying to think of the visuals here. But we want communication to be flowing. And so, we want employees to be understanding what they need to do and how they can do it, how we can help them do it, again, going back to that purpose. And we also want managers to be understanding what is going on with the employees and how they can help their employees achieve those goals.
Yeah, and it's an important concept because I've seen my friends on the plaintiff's bar use the absence of that to great effect when they are deposing a manager who has a subordinate that was terminated, and maybe the performance appraisals weren't as robust as they should have been, maybe not so much notice was given, and this concept of, well, isn't part of your job to manage, to support your subordinates, to let them grow in the organization? And believe me, they're not going to tie these concepts together when they're asking the questions. They're going to spend the first part of the deposition talking about what your job is, what you're responsible for. Yes, I manage employees. Yes, I'm responsible for identifying leaders and helping them grow and things like that. And if your managers aren't held to account, if it's just sufficient for me to spike someone in the evaluation and let them twist, and then 3 months later say, well, they really haven't improved, so now I want to let them go, that's not such a compelling story to tell. On the other hand, if I give someone a bad evaluation and I can say, and here's what I did, the next month I sat down with them again and we went over the task of deliverables and said, hey, you're doing better on this, but you still missed 3 deadlines last month. We need to do better about that. If you can show that feedback loop and active management engagement, it's a much more defensible circumstance than simply a bad evaluation and then 3 months later the individual was shown the door, with managers not actively engaged and trying to get this person to succeed.
And then I love this last one because we're talking a lot about litigation and we're talking a lot about deficiencies. But this last bullet point is great because not only are we talking about per performers, but here with performance management and your appraisal process, you have the opportunity to really identify your rock stars too. And then that's a great thing. And identify your candidates who may be eligible for that bonus or that raise or advancing to a new position or a new opportunity. So, it's the stick and the carrot. It's the good and the bad all rolled into one. But, we shouldn't think of performance management just as a punishing tool. It's also a way to identify our stars as well.
Yeah, and to that point, if you're looking at the performance appraisals for, if you're a people manager, if you look at the appraisals that you've done for your team and looking at the appraisals, it doesn't leap out at you who are the superstars and who are the lower performers. Either the process or the tool or the implementation is broken. You want to see that differentiation, and there's in the industrial organizational psychology world, there's this notion of validity, and is an instrument really measuring the tools or measuring what it needs to be measured to be have success in a given position? That's one of the things that they look at. Like, does someone with a good evaluation, is their performance better than those with bad evaluations? Are they the ones that rise in the ranks? So again, if all the evaluations look the same, or if you can't discriminate, something is broken in the process and needs to be addressed.
We have one question from the webinar, and obviously there's no easy answer here. It's going to be extremely fact-specific and organization-specific. But what happens when performance, someone's engaging in some poor performance, there is a performance management process in place, performance improves but not enough?
Yeah, we'll actually touch on that one a little bit later about the sort of the yo-yo performer or the death of 1,000 cuts. They're difficult situations to deal with, and they're ones where having a robust process really comes in handy, because if you have the performance appraisal that identifies 6 areas of deficiency and they've improved in 3 of those, have they shown improvement? Sure, but they still aren't meeting expectations. So I'm going to feel okay if a manager says, yes, they've improved a little, but they're still not at our level. I think you're still in a very defensible, place. Now, if you don't have that robust instrument and you can't say that, yeah, you saw improvement in 2 dimensions but not the other 4, it becomes more difficult to defend a circumstance like that. That's why having good tools and following them and implementing them right is so important. Okay, moving over to discipline. We're not going to spend a lot of time on the principles here because, candidly, they very much echo what we've been talking about in performance appraisal. So, although not on the slide, when you're disciplining, be it a verbal reprimand or a written reprimand, being able to identify that objective conduct. What is the conduct that has given rise? And so, again, not just a bad attitude, but as we've talked about in the past, poor attitude, for example. And making clear that you're not identifying, this isn't a universal document that lays out every piece or every example of this individual's bad conduct. It's just providing an example of it. So, if that manager is no longer here in 2 years when we're having to fight about this in litigation, you've got a document that, tells a story and tells it in an objectifiable way is very important. Consistency in practice is essential. One of the first questions that we ask when we're called into a circumstance is, hey, here's what's happened, and we're thinking about terminating this individual. What do you think? And one of the first questions we ask is, has anything like this happened before? And usually you don't have circumstance that's going to be exactly on all fours, but generally speaking, particularly organizations that have been around for a while, poor performance and terminations are a fact of life. Where not every employee is going to make it, not every employee is a good fit for a given organization, and terminations do occur. That's fine. What's not fine is if a plaintiff can point to someone who engaged in similar misconduct but wasn't terminated, something they were treated more favorably, the other person was. It's just what we refer to as a comparator. So it's essential, and that's why the consistency is so important, because that's where cases rise and fall when we're trying to explain what our legitimate non-discriminatory reason was for a given decision. If that same circumstance happened before to someone who looked different, to put it bluntly, that's a problem. Does it mean that you've broken the law? Absolutely not, but it is something that we would have to address when we're explaining why certain decisions were made. Following written policies, we want to ensure that, or we prefer that organizations have written progressive discipline policies to put people on notice of, major offenses or samples of major offenses that, so people can't say, well, gosh, I didn't realize that was, that type of conduct would be a problem here. You also want to be certain, though, that your progressive discipline policy does not make it mandatory, i.e. it's discretionary. That, yes, we may, in a given circumstance, do a verbal warning. It may be suspension. It may be, whatever the scale is. But we, management, get to choose, and we're not required to step through, various processes. And again, finally, documentation is key. Having those accurate records, having them be contemporaneous. We'll talk a little bit later about using certain tools to clean up a circumstance where maybe our documentation isn't as robust as we would like it to be, but having the contemporaneous documentation is really essential when we are called upon to defend disciplinary decisions. And again, keep in mind that oftentimes charges don't come in the very next day. Sometimes they do. You terminate someone and a week later you've got a demand letter. But they can sit for a while. EEOC's 300 days. The local laws tend to be around 12 months. For race discrimination claims under 1981, that statute of limitations is 4 years. So imagine the turnover that can happen in your organization over the course of 4 years, and that's again why documentation is so important, because that file is not going anywhere, hopefully. But the managers who are involved can move on. So again, documentation essential when we're talking about discipline.
And David, if I can just add, here where he's talking about following written policies, perhaps taking a step back even further, develop written policies. We love that. If you want to come to us and have us help you write your written review or write policies, again, so you can be managing your employees' expectations clearly in writing about what the process will be. But if you already have a written process, making sure you have this exclusion that David talked about, meaning it's not mandatory. We did work with a client. We did not write their policies. They did not have an exclusion. Somebody committed a pretty egregious offense, was terminated immediately, and stood on top of that handbook and said, you, the employer, did not follow progressive discipline. I was not treated fairly, and it was because of this protected characteristic. I can tell you now their handbook does the right to terminate immediately, but that's just something I wanted to emphasize.
Yeah, and it's an important point because plaintiffs' lawyers will use the policies against you. Mm-hmm. And if they're poorly written, and I had a client that had, instead of just major offenses or sort of the do not do these things and here's some samples, they had certain offenses were identified as ones that will get you terminated. Mm-hmm. Certain offenses were ones that will likely get you suspended. So this person did something that was in the likely suspend category and was terminated, and the plaintiff's lawyer is waving it around. Now, of course, I'm waving it around back at the section that says this is not an employment contract and, et cetera, et cetera. But there is decisional law in certain states. Thankfully, here at D.C. and the Fourth Circuit particularly, it's where management lawyers go when they die. It's very employer-friendly. But not all jurisdictions are like that. And so that's why having the policies that are well-written, well-crafted, and once crafted, living by them is very important because they will point to that. Okay, some common pitfalls. And we're going to start with botching or ignoring performance management. Some of this we've touched on. Talked about the performing appraisals on time and unfairly. Or rather, uniformly, not unfairly. Let me clarify that. Second bullet is probably the most essential, training managers and holding them accountable. People managers should themselves be evaluated on performing evaluations. So if they are not getting their evaluations done on time, or if they're, as we talked about earlier, allowing performance issues to fester and not using those other tools, not engaging in that feedback loop, they should be held accountable. I will tell you, getting managers to do evaluations on time can be difficult. And Jeff and I, we did a condensed version of this as a quick hit a couple of weeks ago, and one of the attendees indicated that they were having such an issue getting appraisals on time that they modified their bonus system. And managers were not eligible to receive their bonuses until they completed their appraisals. The appraisals started coming in on time. So, monetary incentives, the lessons, monetary incentives are powerful. And that's a very good tool when you're dealing with managers and trying to, keep them in their lane and keep them performing what they need to be.
And Dave, on that front, it's not uncommon, and it's generally a good practice, particularly for large organizations. One of our clients just a few weeks ago had all of the managers come together for a training session on how to do performance evaluations. And this type of a session, but focused on the managers. I think in that case they use their in-house HR staff to do it. Sometimes you bring in an outside consultant, sometimes you bring in folks like us. But whoever it is, it needs to be someone who understands the do's and don'ts in this area. And you really need to train the managers because, frankly, unless someone's been doing this for a long time or has some kind of an HR background, this stuff is not instinctive. And you guys didn't come to your jobs. I mean, maybe some of you who are HR specialists came to it with a lot of training in the area, but most of you come because you're substantive experts in the issues that your nonprofit deals with, or you care about the cause, or you just happen to work your way up from some other method. And you didn't go to school for this. You didn't have any proper training in this, and it's not instinctive. It's not all instinctive. So training the managers to do performance evaluations is a really important tool.
No, absolutely, and I think your industry in particular tends to promote from within. So oftentimes, Jeff, to your point, you've got subject matter experts who rise in the organization, and managing people is a skill, and typically it is a learned skill. And many organizations overlook that fact because they think, well, the person's been at the organization, they know us, they know our culture, they're a subject matter expert, they're going to do just fine as a director. And allowing someone like that to twist without giving them the tools and the skills to be able to effectively manage people, you're not doing your organization any favors. So that type of training, be it internal or outside, I think is really essential. A couple other problems that we see in the performance management. We talked a little bit about this, leniency. It's sometimes hard to give feedback, so people don't. And I mean, I cannot begin to tell you the number of cases that I've been involved with where the first line of the complaint and the first line of every pleading that was filed in that matter said something along the lines of, after 15 years of sterling performance evaluations, Jane Doe was summarily terminated. And it's a bad fact to have to deal with. And it happens all the time because, again, one of the questions we always ask when someone wants to terminate or wants to suspend is, okay, can I see when was their most recent performance appraisal? Can I see it? And if it comes back and says Jane's doing a great job, I'm going to push back on the decision to let Jane go. So leniency is a problem. The halo and horns effect also happens. You've got someone who's really good at one aspect of their job, but not so good at others. We've got a slide about sort of dealing with bullies in the workforce and the like. We hear it. We say, well, John, he gets results, but he's really hard on his subordinates. But I'm not going to call John to task because I want him working hard and he's doing a great job for the organization. Yeah, it's a problem. John needs to be told that he can't yell at subordinates, and that communication style and developing talent is something that we hold managers accountable for. So be careful when you see a performance evaluation that is sterling across the board. Your superstars, even the best person, can always enjoy some constructive feedback. Similarly, it's very seldom that you have someone who is just horrendous across every dimension of the job. So when you see those types that are uniformly positive or uniformly bad, and the uniformly bads, oftentimes they just read like hatchet jobs, particularly if the 3 prior years were all very good. And then suddenly the same manager is saying that this person's terrible at their job. Okay, well, what changed? Is what changed now you want to fire them? You've now developed the gumption to finally get rid of it? Still going to have to explain away those prior very positive performance evaluations. Finally, having a system for cross-checks or appeal. Most small organizations don't have a formal evaluation appeal process or ombuds, but even in smaller organizations, having a cross-check, having managers maybe share their appraisals across one another and say, hey, could have a different department look at the performance appraisals from another department, or for larger organization, having a one-over review so that the director's performance appraisals are reviewed by the senior director or maybe the executive director, who probably isn't going to have complete visibility into all of the issues that are being addressed, but can at least give a fresh set of eyes and say, okay, if particularly where we're calling someone to account, are we giving them enough feedback? Are we showing how we're going to support them moving forward? Having additional eyes tends to mean less bias, as well. So having at least a system of a cross-check, very, very important, and tends to get much more better documents out of that process.
Okay, so now we've talked about all of these tools, if you will, in your management tool chest. We've talked about progressive discipline, performance improvement plans, appraisals. Right now we're going to focus in a little bit more on performance improvement plans, or PIPs. Your PIPs should provide objectivity. You've heard us say a few of these buzzwords over and over again, like consistency and objectivity, because again, we want to, as we said before, clearly identify those performance deficiencies. And earlier we explained why from both a practical and legal risk standpoint. Also, as we addressed before, providing the opportunity for improvement in your PIP. We love timelines, where you're going to be assessing performance over whatever is appropriate, the next quarter, 60 days, 90 days, et cetera. And sometimes, and David, I'm sure you've seen this too, certain organizations will either set the timeline in the PIP, which is great. We will be reviewing your performance over the next 3 months. Sometimes I have seen where the timeline is not in the PIP, it's on the management end. That gets a little trickier.
Yeah, I mean, it's what you want to have is the employee. You want to have put the employee on notice as to where what this period is going to be. Set the expectations. It's a heightened scrutiny that they're being subject to, and how long it's going to last. Really up to management. I prefer to have it in the document itself.
Likewise.
To sort of set it in the ground. Very important to have language in the PIP that makes it clear that this is not an agreement on our part to keep them employed during the next 30, 60, 90 days. They remain an employee at will. We'll talk about some of the magic words that we like to see in these, but generally what you don't want is a document that they can point to and said, well, they told me they were going to give me 90 days to improve, and they terminated me 2 weeks later. Is that illegal? No, but does it make the process look less fair if the employee's not on notice that they may not make it throughout the entire 90-day period? I would say yes. The other thing, the time period should be individualized, meaning that you want it to be fair. Think about if you have a senior manager who's having communications issues or issues with subordinates. Issues like that tend not to be resolvable in 21 days or 30 days. So if you want to give the person an actual opportunity to succeed. So many times, particularly when you're dealing with senior managers, you're talking about a quarterly or a 90-day period, and certainly one language that says we can extend it if we choose to. But you want to have both a process and a document that's fair. And so that the question is, well, how are they really going to patch up their team in 30 days? That's not doable. That's probably right, depending on what the circumstances are. So you want to be certain that the process and the process as implemented is giving the individual a fair opportunity to bring their performance up to where it needs to be.
And a lot of employers don't like to have that in writing because of these issues of, because of these issues of say, what if this happens at the next meeting, or I don't want to bind myself to the 30-day period. And again, that's why it is not only individualized, but we want to be careful how we craft the language. But it's just a matter of setting expectations for the employee. So it's also more productive for you. So you don't have the employee coming back each week saying, have I improved? Have I improved? Is it done yet? Is it done? Is the axe off of my head? So it's sort of just, it sets a plan for everybody. Everybody's expectations are somewhat managed. Clear performance targets, we have talked about this. It is difficult, as David said earlier, when you're not in the factory setting and we can't say, you have to produce X number of widgets in X number of hours. But when you really think about it and talk about it internally or with us, whatever process works for you, we can help you identify what these performance targets are, whether it is a matter of getting documentation in on time, or whether it's a matter of, working well with others. These things are sometimes harder to define, but they are objective standards. So we want you to be able to identify these clear performance targets. for the employees. And then we have this quote in here, and we're going to expand on this further in just a minute, but immediate and sustained improvement. This is twofold. This is important. We not only want the improvement to be immediate, we want you to be getting the message, and we want you to be improving ASAP. But it's not good enough that it happens today and is gone tomorrow. We want it sustained, or else what's the point of keeping you around, right? Did you want to expand on my flippant summary of that?
Well, I'll expand on her flippant summary in one slide.
Okay. And we want support from management, okay? And this can happen a number of different ways. You'll see here we have the phrase open door. A lot of you have worked with us on your handbook policies, and we love the open door policy where it's love and peace and happiness, and all of the doors of all of our managers are open to everyone. And it sounds nice and good, but it's not just weaving daisy crowns in the fields. It really has a practical aspect to it, which is if you have an employee who's not necessarily comfortable going to his or her manager, you've established a culture and even have a written policy where that employee can go to another manager to talk about performance issues, performance improvement. So we love open door policies.
Yeah, simply having that feedback loop and stating it to the employee that if there's an issue, if there's a concern, if you're confused about what success looks like, you can always talk to your manager or HR. So it's not what you want to do is have it set up so the employee later can't say, this entire thing is a sham, no one told me what I needed to do, and I was confused, I had nowhere to go to. You want to cut off that argument and say, here are the resources. Again, it doesn't have to be executive coaching or anything like that. It can be as simple as, come talk to us if you have any questions about what our expectations are. That's oftentimes sufficient for these types of things, but oftentimes it's overlooked.
And you do hear employees saying, well, I would have, but I don't feel comfortable talking to X person. Again, this open door policy, well, look, you can talk to any number of people. But also, encouraging scheduled meetings with supervisors, and this can be executed a number of ways as well. Communicating that to the employee, communicating that to the managers. Sometimes we've even seen clients who have various office hours with different managers.
Very important that those meetings, if offered, actually occur.
Yes.
One of the things we have seen is a performance improvement plan. It's going to be every 60 days, and we're going to meet every other Friday to talk about it. 60 days goes by, and none of those Fridays meetings occurred. The employee, is in a better footing to say, they knew that I needed support. They told me that they were going to support me, and they didn't. Illegal? Probably not. Unfair looking from an optics standpoint? Probably. And certainly not helpful if we're called to account to why we made certain decisions. So that's why it's a tick of management lawyers. If it ever says the company shall or management will, well, if we say that we're going to, we have to. And so, again, here's another opportunity where supervisors need to be held to account in this process.
And these concepts kind of flow over one another. They overlap a little bit, including the last one, mentoring. You can implement a formal or informal mentoring process, and that really depends on the organization and the individuals in the organization. So coaching your managers to have their doors open, to be a part of this feedback loop, that's a type of mentoring. Some organizations take it a step further, and they coach their managers to be mentors to those who need performance improvement. And then some take it even a step further and have a formal mentoring system where mentors are assigned. Now, David and I were just talking about this the other day. You want to be very careful with that because not everybody is a good mentor. You can have somebody who is great at their job. In fact, they're even a great manager, but they're just not a great mentor. And so you don't just want to say, well, your name's next up on the roster. You're going to be mentoring that itinerant Jeff Tenenbaum, and then it's a system that blows up in your face. So again, with all of these rules, you're going to want to tailor everything to the individual organization and the individuals at hand.
Yeah, mentoring can be a very effective tool, but it has to be used very carefully because if you match the wrong person, and be it both the mentor and the mentee, if that's a mismatch, it's a death knell to the mentee. They're not going anywhere in your organization, and it's going to make matters worse. So I for one, am not a big fan of the sort of forced matching mentoring system. Some large corporations use them and some use them very successfully, but my observation is when it doesn't work, it can be catastrophic. So be careful as to who you're selecting and be careful in the matching process.
Okay.
Before you move on, we have a question from the webinar. We've had some turnover in senior management and have found it challenging to adequately review those subordinates reporting to the terminated manager. So there were a bunch of subordinate employees reporting to a manager who got terminated, and they're having trouble adequately reviewing those subordinates. Do you have suggestions on how to manage this transition?
That's a difficult circumstance, and I will say many times organizations simply punt and say, because we don't have an adequate sample size, if you will, we haven't been able to evaluate you over a meaningful period. If there wasn't any exit interview process, if for whatever reason the senior manager just disappeared, it can be very difficult. And I would say, generally speaking, I would recommend that organizations, as opposed to simply making it up on the fly, you simply say people are going to get average increases. So if the merit increase pool is, the average increase is 3.5%, that this department is going to get 3.5% this year. Now, you can also hold off on it and say, well, what we're going to do is a shorter evaluation cycle, and so over the next 3 months there's going to be sort of a rigorous review, and we'll make determinations at the end of that 3 months, and we'll make whatever changes we make retrospective, so that the people will be kept on equal footing. It's a challenge. There's no one right answer, but I think either of those would be adequate to address it, particularly if there's just not enough data for the new manager to come in and say, who gets 5% and who should be getting 2%.
Okay, and so then I mentioned earlier that I think we have another question in the back. Okay. Oh, I thought you were saying you were in the chat.
Just had a quick question on having immediate and sustained improvement, but also a timeline for improvement. If you're giving a timeline, say 90 days, how does that reconcile with it needing to be immediate? So are there benchmarks along the way in that 90-day period?
Well, that actually leads directly into our next slide quite nicely.
Great.
Yeah, so we'll go ahead. This is your slide, I think.
Oh, okay. So and feel free to jump in because I could not hear the entire question. But if the answer is in my magic words, are they in the magic words? Is that what you're suggesting?
Yes, that's what I was suggesting.
Okay.
I'll go ahead and jump in since I'm not certain Megan caught the entire thing.
I could not. I apologize.
The message is in that first clause, immediate and sustained. And sustained doesn't mean for the next 90 days. Sustained, with my management lawyer hat on, means forever, that you need to meet our performance expectations. The 60, 90-day, 30-day period is really just to sort of put a frame around the fact that you've got a microscope on you, or pick your tool of the visual expansion, that for the next 30 days, you are being subject to heightened scrutiny because we have an issue, it needs to be resolved. Once you get out of that period, that's where these words become so important because we talk about, if there are any further problems with your performance or violations of rules, policy, blah, 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 you will be subject to further discipline, including immediate discharge. What we don't want is a performance improvement plan that wipes the slate clean, that says, David, if you make it for the next 90 days, you're back at square one, and then we're going to start ratcheting up the discipline again. That's not how PIPs should work, and that's why this type of language is so important. What the PIP does is say, you have been failing. We're going to give you an opportunity to bring your performance level up. But once you're out of it, we still have the same expectations of your performance. And if you fall back down, if you're that yo-yo performer, the next time you go down, it might be the door. So that's how the two interplay.
And not only practically is that helpful, but also we keep talking about this dual role of practicality and litigation risk, but also that documentation is helpful to have that history. I mean, we learn from history, right? We don't want to erase it, and the same applies here to your performance improvement plans. So you don't want to be promising to your employees, if you do this, we will remove this from your file. If you do this, it goes away. We want to maintain that history and documentation.
And I'm mindful of the time and also my need to run screaming from the building at 2 o'clock to get across town. So we'll move pretty fast through some of the other remaining concepts here. Lawyers love PIPs. What they provide is what we like to refer to as a roadmap for summary judgment. All of the concepts that we've been talking about in terms of identifying the performance deficiencies, a reasonable performance target, that opportunity for improvement, support from management, that's an incredibly powerful narrative to be able, when we're held account, to say, this was not a summary execution of this individual. They were informed they were having problems. They were told that they needed to improve. They didn't improve. That's going a long way towards us to get out of a case early, i.e. at summary judgment, as opposed to having to litigate something and take it to a jury trial. And the difference in those two is astronomical. Because it's one thing to have to litigate, do some depositions, and do motions practice. It's quite another to try a case. And believe me, it's terrific fun for lawyers. It's part of my litigation. That I love it. It is no fun for my clients. And what you want is to have a case, have a defensive case that you can get out early, and the PIP gets you a lot of the way there. Last bullet, very important, clean up a lack of earlier documentation. PIP's a great document to call back to history. Many, many times, we're dealing, particularly in smaller organizations, say, this has been a problem for a while. I've been talking to this person about this for months. I'm at my wit's end. Say, well, is any of it documented? Any emails? Well, there might be one or two, but really it's just been phone calls. It's been meetings. We're a small office, and we talk about it. So it's, okay, not ideal. But when you're doing that PIP, you say, beginning with our discussions in January and then continuing in March, you create that document trail to take credit for all of the things that you did orally. Is it perfect? No, but it does do, it helps in terms of creating a paper trail, and I don't mean that in a pejorative sense. Disciplinary pitfalls, leaping to decisions. One of the advice I always give when people are, particularly at the point of termination, is to simply slow down, to take a step back, collect the documents that are surrounding this performance issue. We can talk at length about the final bullet about if it's an issue that's going to require investigation, if it's a harassment type situation, have a thoughtful discussion or a thoughtful decision about who's going to do the investigation. Should it be in-house resources? Do you have in-house resources that are sufficient for that? Should it be outside counsel? If it's outside counsel, there are issues around conflicts and whether or not the outside counsel who performs the investigation can actually represent you at a later trial. So it's too much of a decision or too much of a too nuanced an issue to discuss at length today. But if you have that circumstance, it's something that should at least be identified and discussed, so a thoughtful decision can be reached. When you're talking about discipline, conduct a prompt investigation. As I say, not every issue deserves the full CSI treatment. But you always want to have, at least a fact-gathering component, so it's clear that it wasn't simply a snap decision, that it was a thoughtful one on the part of the organization. Consider whether a document hold is appropriate. In many, many circumstances, particularly if it's an issue of harassment or egregious misconduct where it's likely that litigation might ensue, think about whether it's appropriate to issue that directive to all the parties involved and say, maintain all the documents about this, don't delete your email, retain all of your emails involving this situation. Failing to do that can lead to very tricky issues called spoliation, and so that's another issue that you want to flag for your organization and make certain that a thoughtful decision is raised or is made on that. And then determine the appropriate discipline using the following steps.
Okay, so we have step one. This is the pitfall is failing to realize that discipline is a process, not an end. So step one is confirm that discipline and or discharge does not violate a forgotten or hidden promise. So this is not a decision to be made in the bubble. You're going to want to review the relevant employee's offer letter and or employment agreement, your employee handbook, and any other standalone policies or employer memoranda. You might have, for example, in an offer letter and agreement, a required notice period prior to discharge, and the agreement might provide for pay in lieu of notice. That's something you're going to want to take into consideration. Or, for example, the agreement might provide, or the handbook, for severance if the termination is not for cause. And if it's not for cause, what does cause mean? So again, don't make this decision in a bubble. Make sure you're reviewing all of your relevant documents and policies. Step 2, we want you to follow a disciplinary system progressively if possible. This is one of the things we were talking about before with the coach and counsel, the written warning, the suspension. You can tailor your disciplinary process to your organization's needs, and you can tailor it to the specific situation and individual scenario, but we do love, as David said before, progressive discipline. And that allows us to consider alternatives short of discipline, even something as extreme as an unpaid suspension. And as David said earlier, we don't want to overlook the power of monetary incentives. Suspensions without pay for our exempt or non-exempt employees, we're just going to want to make sure that we are not violating any wage laws such as the Fair Labor Standards Act and making an impermissible deduction. David talked about that earlier. If you have a written policy for a conduct violation.
And also on that front, if you're dealing with incentive compensation, it can raise state law issues. Maryland in particular, for those of us who are local, has a line of authority that in essence said, once a bonus or commission is earned, it's earned. It might not be payable until a later date, but it is earned wages. And so withholding something like that could give rise to a very straightforward wage payment claim, which has treble damages and attorney's fees shifting. So this is one of these, I encourage you to make certain that you're dealing with your outside or inside counsel when you start playing with compensation, because you can trip yourself up in ways that can be very expensive.
So that's that next bullet point there, reduction of bonus potential. And what David's talking about there is not only a bonus structure, but commissions as well. New York, for example, has pretty strict rules regarding commissions. And another thing is not withholding the pay, but delaying a pay increase or bonus. So you're not taking it off the table, but you're dragging it out. Okay, step 3, give fair warning. We said this at the start. We want these employees to see it coming. We want to put the writing on the wall even if they're not willing to read it. It's helpful for them, whether or not they know it, it's helpful for us. So a performance improvement plan, if possible, providing the opportunity to improve. We've discussed the benefits of that. And also, as we said before, we don't want to wipe the slate clean. We don't want to remove or promise to remove a certain appraisal or plan if the improvement occurs. History stays in the books, people.
Step 4, answer the critical question of what's the articulated reason for the discipline or discharge. This is essential because once it's articulated, you're stuck with it. And it's very bad for employers if in one part of the process they give one reason for a discipline or a termination, and then later they change their mind and say, well, really what was going on was an attitude problem or some other performance deficiency. It's in the case law what we call shifting sands. And once the employer's reason begins to shift, that there's a presumption of pretext, that it's all a sham, and really what was going on was discrimination based on insert protected characteristic here. 5, we talked about this. Do comparisons. Make certain that if there were other circumstances that were similar but were handled differently, why is that? What's our explanation? This is one where institutional knowledge becomes very important. So if you've had management turnover, these are issues that need to be looked at very, very closely. The public policy check. What are their blind spots? Has this person? We always ask this question. Have they raised complaints lately? Has there been any issues that they've brought forward, i.e. are you stepping into a retaliation context? This is not to say that if someone has complained that they're not going to be subject to discipline or termination, but you want to have your eyes open to the fact that you're going to have a potentially valid retaliation claim coming, and how strong is our defense to that? I've had circumstances where an organization wanted to terminate, and I said, listen, you can do that, probably lawful. Probably not going to be able to get out on summary judgment. So can we stomp on this person in a way short of termination, and that might be equally effective, i.e. suspension or bonus withholding, et cetera. Handle the discharge conference with care. It's always a difficult conversation to have. It should be brief. It should be succinct. You shouldn't be debating the decision in any way, shape, or form. It's informing the individual that the decision has been made. This is yours, isn't it?
Yeah. Fine. Step 8, continuing with this idea of off with their head. Post-decision considerations. So have you, the employer, complied with applicable wage payment laws? So that is state by state. Are you going to have to pay that final paycheck the day you terminate, the next business day, within 3 days, the next payroll, regular payroll? These are all examples of actual state laws. And additionally, what is the state applicable law on vacation, and what does your employer policy say about that? So accrued but unused vacation. So for example, in certain states like California, that's wages that would need to be payable at the time of termination. Severance policies. So do you have a policy in place that you need to be complying with? Have you created a policy through practice that you need to be mindful of? And then also the administration of benefits and insurance law requirements. Another reason, again, to not to self-promote, but to have you come to us in advance of this so that we can make sure that you're straight not only from these law and policy standpoints, but also COBRA and benefits administration. And then reference requests. Do you have a policy for reference requests? And if you don't, is this a situation where you want to get out in front of it and say, okay, I direct all requests to X person at X contact? And if it's a situation where you want to provide only neutral references, go ahead and say that too in the termination letter, or have a policy to that effect. We will only confirm title, dates of employment, and possibly salary.
And the severance issue has become a real one. For years, it was not treated as a term or condition of employment. The EEOC has taken the position that it can be in certain circumstances. So if you have a practice of giving, four weeks of severance, and that's shown to be a practice, and then someone in similar circumstances gets no severance or one, at least in the EEOC's eyes, that could give rise to an allegation of discriminatory conduct. So it's something that has changed relatively recently, so I'll bring it to your attention. I think we've actually touched on all of these throughout the presentation, but these are some of the other tools that we see used and can be used to good effect. Think about whether outside resources, be it an executive coach or other third-party intervention, if the person's not getting it internally, bringing in that outside resource oftentimes can be very effective. It also can provide another witness in the room who talk about the proactive things that management did. We talked about compensation. It's very often overlooked, and it's an incredibly powerful tool to use in terms of behavior or performance management. Suspension. And then last chance warning, it's akin to a PIP, but you really can't put the writing on the wall any more than if this happens again, you'll be fired. It's not right in every circumstance, but if you're sort of at the end of your rope but you're not quite there, a last chance warning is an extremely powerful piece of evidence if you pull the trigger downstream and the person comes back and says, oh, well, they did it because of X, Y, and Z. And unfortunately, I believe, oh, wait.
This is you. This is you.
Yeah, I'll talk really briefly about this because my apologies, I have to be across town for a deposition in a few minutes. Disability and discipline, and also job-protected leave and performance management. The rule, or rather the point here, is you need to look at both of those issues separately. Even in a disability context, if the conduct is related to the disability, that doesn't necessarily mean it's a get-out-of-jail-free card. So I will use the example of, let's say that you have an individual who is an alcoholic, which is a protectable disability. If an individual shows up to the office and is inebriated, they don't get out of jail free simply because they say, well, you can't hold this against me because I'm an alcoholic. It's not how it works. You can still respond to the objective conduct at issue. That is, if you would treat a similar situation in similar fashion. So you always, while those issues are intertwined, and if you're dealing with someone with a disability, you have to be mindful of it. You have to answer the question, would this conduct have occurred had we provided a reasonable accommodation? Because oftentimes that's what we hear in these cases, say, well, I asked for an accommodation, they didn't give it to me, it was reasonable, and that's why my performance was deficient. Those issues can be very nuanced. So when you're dealing with employees that have disabling conditions, I strongly recommend that you have either very seasoned HR and or employment counsel to look at those issues because they can be very, very difficult to unwind. Similarly with job-protected leave, simply because I've taken FMLA or DC FMLA, it doesn't insulate me from discipline. However, you need to be mindful that it may provide a hook for a retaliation claim, so you'll want to make certain that all the I's are dotted and the T's are crossed if you're going to be, disciplining and certainly terminating an individual that's recently had job-protected leave. Again, simply being out doesn't mean I'm guaranteed employment. I'm only permitted, it only brings me up to the level of as if I were still actively employed. So you can terminate, you can discipline, you can RIF, but the frame is going to be slightly different if you're called to account for those types of situations.
Okay.
Now, with that, I will turn to common challenges and apologize for my absence.
Thank you so much, David. So we just have some common challenges here, and each of these I, again, want to be mindful of everybody trying to go, but touch on points that we have made before, and those are just sort of personified. So the bully. Why are all of my subordinates so useless? This is a communication issue with your manager. Figuring out, the problem here often is the manager, not the subordinates. And so, again, reviewing that position, reviewing that individual, and determining where the problem is and how we can correct it. Similarly, the toxic coworker. I hate this place and everyone in it. I'm just going to kind of go through these because I want to be mindful of your time. The borderline or yo-yo performer, somebody who's going up and down. Again, how are we handling these individuals? What are the objective standards that they have to meet? We want sustained performance. The wrong fit, I really wanted to get to this one. I can't put my finger on it, but it just ain't working. This is, again, where we want you to be able to get to a place where you can identify what is not working and how it can be fixed. Because you really can tread in dangerous territory where you're just getting rid of somebody and telling them that they're not a good fit, and they say, well, that's interesting because I'm the only woman in this place. Tardiness and attendance issues. I mean, this is I know a tough one, but relatively easy in that you have that objective standard set for you right there, and how they can improve, and it's really easy to see if they're not improving. And the true believer is always tough. You can't fire me because I'm insert protected characteristic or category here. And, we want to be mindful of these individuals, handle them with kid gloves to a certain extent, but do not let them prevent us from exercising our rights as employers to have a productive workplace and terminate them if necessary. And a lot of that, again, with all of these, communication's going to be really key. The problem here is that you have an attendance issue. So not engaging in that discussion of protected characteristics, but sticking with those objective standards and how they can meet them. And so with that, I apologize that we had to rush through the end of this, but you guys had so many great questions. I think it's been really productive, and I thank you all very much for your time.
Thank you, Megan, and thank you, Dave, for a terrific program. We'll stick around up here for a few minutes afterward if you have any questions. Otherwise, we hope to see you back here next month for our next program. Thank you for coming and attending.